Welcome to the final chapter of abnormal psychology, and for this semester, this is the legal and ethical issues, and this is going to be very focused on the concept of being legally insane and committing someone uh, to an institution or to a prison. So this is not a wide-ranging study, and it's a relatively short um, voiceover PowerPoint. So criminal commitment, uh, people who are accused of breaking the law are subject to commitment in an institution of some type. Um, and they can either be put into a mental hospital for a determination of competency, that is, to see if they are competent to stand trial, or if they've been acquitted by reason of insanity. Uh, and so the part of the law is there's no crime without an evil intent. So if somebody can't tell the difference between right and wrong, uh, then they can't be guilty of committing the crime. That doesn't mean they get to go free. Okay, so keep that in mind. So the insanity defense is played up quite often in the movies and on TV and so forth, but it's not used that often because the downside is pretty dramatic. Um, Insanity is a legal term. It's not a psychiatric term. It's not a psychological term. Okay, and it's based on the mental state of the accused at the time the crime was committed. So uh, that's where you get the concept of temporary insanity. At the time the act was committed, I lost my mind, so to speak. Um, so in an insanity defense, the defendant is not responsible for the act or the illegal act if it's attributable to the mental illness or they didn't know right from wrong. And quite frankly, it's rarely successful. Okay, uh, and it requires judgments by lawyers, judges, jurors, and clinicians. And just about any one of those along the line uh, can can wreck it. So these are the landmark cases. They're in your text, and so it's just kind of look down those quickly. The McNaughton rule followed the irresistible impulse, and that was the first one uh, that really got into did they know the difference between right and wrong? And then after that, we had the Insanity Defense Reform Act and so forth down the line. And in '75, they had the guilty but mentally ill. Okay, and we'll talk a little bit about that as we move forward. So there's two kinds of insanity pleas. The first one is the NGRI, or not guilty by reason of insanity. So in this case, there's no dispute over the guilt. The accused is deemed not responsible for the crime because of mental illness, and they can have an indefinite commitment to a mental institution, forensic hospital, and they're only released when they're deemed no longer mentally ill. So John Hinckley, who tried to assassinate President Ronald Reagan in 1981, was not guilty by reason of insanity. Now, he served until September of 2016, and when he was released, and now he lives at home with his mother. Uh, his verdict uh, was the cause of the 1984 Insanity Defense Reform Act. Um, then the next type is the guilty but mentally ill, GBMI. Uh, Persons found guilty of the crime, they are listed as mentally ill. It plays a role in the sentencing. Uh, they can be committed until they're no longer mentally ill, but then they're sent to prison to serve the remainder of their sentence. Most of them just go directly to prison and may or may not receive any psychiatric care. So Jeffrey Dahmer, who was also known as the Milwaukee Cannibal, he was a serial killer, sex offender, committed rape, murder, dismemberment, I think of about 17 men and boys between 1978 and 1991. He was guilty of cannibalism, and so he was diagnosed with borderline personality disorder, schizotypal personality disorder, and psychotic disorder. But he was found to be legally sane at his trial, and so he was convicted of 15 terms of life imprisonment, uh, and was serving those in an Ohio prison. And in 1994, he was beaten to death by another inmate. So here's just a quick look at comparing the two. So the not guilty by reason of insanity says they're not responsible for the crime. Guilty but mentally ill says they are. The NGRI goes to mental hospital. The GBMI goes to prison. NGRI, no sentence. GBMI, yes, they get a sentence. And then, so you can see the rest of how it plays out there. So, competency to stand trial. So some people are ruled incompetent to even stand trial. If the person can't consult with his lawyer and be rational, they're not even competent to stand trial. And they have to have some type of understanding of the procedures that are going on around them. The determination of competency is made before the individual is tried. So there's what they call synthetic sanity, and that's if medication can produce rationality, the trial can be held. So this is what happened with Robert Deere, who did the Planned Parenthood shooter. He back in 2016, he had 79 counts of against him, 8 counts of first-degree murder, and he was incompetent to stand trial, and then they forced the medication on him so that he could face trial because he was lucid when he was on his meds. So insanity, intellectual disability, and capital punishment. The U.S. Supreme Court has said it's unconstitutional to execute individuals who are insane or have an intellectual developmental disorder. That would constitute cruel and unusual punishment. The problem is with the states, the definition of mental retardation varies. The power of the state, parens patriae, the duty of the government to limit freedoms for other people's protections. So you can be committed uh, to a psychiatric hospital against your will if you're mentally ill or you're a danger to yourself or others. To have someone committed requires a formal court order, and there's if there's an emergency going on, they can commit them until they get a chance to review the case. So the problems with some of these things are, who should they apply to? So some of the stats are when, if substance abuse is not a factor, which most of the time it is, mentally ill people are no more likely to commit a violent crime than the average person. Only 3% of violent crimes are linked to mentally ill people. So if violent, the target is usually family or friends and not strangers for the mentally ill people. Stranger homicide by mentally ill people is extremely rare. So how can you predict the dangerousness of an individual? Repeated violent acts in the past. If the person has to return to the same environment where violent acts were committed and their personality hasn't changed, there's an excellent chance they'll commit violent acts again. And if they're non-compliant with their medication. Now, the courts try to balance the patient's rights with the rights of the public to be protected. And that's why the Supreme Court said the evidence for commitment must be clear, must be convincing, danger must be imminent. And they want to try to go with the least restrictive alternative. If they are committed, if someone is committed, the state is required to provide treatment for that person. Now, they can refuse treatment. That is their right. So there's a deinstitutionalization where thousands of people in mental institutions were put out on the streets beginning in the 1960s and then again in the 1980s under Reagan. Psychiatric hospitals, were almost evacuated. And many cities lacked sufficient community health facilities when this happened. And so many of the mentally ill ended up being trans-institutionalized. A lot went to nursing homes, hospitals, prison. These are our homeless people on the sidewalks. Quite a few of them. Somewhere between 20 and 30% of the prison population is mentally ill, and more often, police officers are required to have to handle the mentally ill. So if you take a look at the graph on the right, so there were 350,000 people institutionalized in state hospitals in 1969, and then over the years that's been reduced, continuing to go down and down to now it's just around 60,000 at the turn of the century. But you see that the mentally ill prisoners almost makes up for that 350,000 that were in hospitals. So they had to go somewhere. So there's some ethical dilemmas that are involved in therapy and research. Probably the most the most horrible one is the Tuskegee syphilis study, where a number of black men, African American men, uh, were actually infected with syphilis. They believed they were getting free treatment. They were told that the spinal taps they were receiving so that they could their spinal fluid could be um, uh, looked at, studied, was therapy, and they prevented them from getting penicillin. This went on until 1972, when finally a press report caused the government to stop the study. So even throughout the civil rights movement in the 60s, this study was going on. So today we have more things going on with the institutional review boards, the IRBs. Researchers have to receive training in research ethics, and they have to ensure that the mentally ill participants understand the risk of research. So you have to get informed consent, uh, and people can quit any study at any time. Uh, so within that, there's the confidentiality uh, and privileged communication. The patient holds the privilege. Now, privilege can be broken if the patient files a malpractice suit against the therapist, if the patient is 16 or under and a crime of or abuse victim. The patient is trying to avoid arrest for a crime committed or planned. If they're planning a crime, the therapist has to tell somebody that that's going to happen. Or again, if the patient is a danger to themselves or others. Okay, that's it, folks. That's the last voiceover PowerPoint. Make sure you take your final exam, and I hope you enjoyed the course and you got out of it what you needed. Uh, as always, if you have any questions or comments, don't hesitate to email me. So have a wonderful summer and enjoy.